Safety Act. We're going to be talking about what are the definitions of harassment, what are the definitions of violence, what are the various parties' duties and obligations. So as you know, there are duties for employers, there are duties for supervisors, there are duties for employees. What are the implications of workplace harassment? So there are human rights implications. There can be implications under the Workers' Compensation Act. There are obviously obligations and, of course, resulting implications under the Occupational Health and Safety Act. And then at the end, I'll sort of do a wrap up and we can talk about what are our practical tips for policy development. I'm going to probably just stop screen sharing for now, or I'll, stop sharing the video of my face for now, so that we can kind of focus on the presentation. Harassment. Okay, so as I'm sure all of you know at this point, employers have a duty to provide a safe and harassment-free working environment to your employees. The way that we need to think about workplace harassment is the same way that we would think about any other workplace hazard. So we need to think about it the way that we've thought about heights and noise reduction and using tools. We have the same obligations in terms of those types of workplace hazards as we do with harassment. And so every workplace will have different considerations with respect to harassment. Again, today we're going to focus primarily on occupational health and safety obligations for employers, and I really want to focus on how we can ensure compliance in your workplace and mitigate risk. So the definition of harassment is any single incident or repeated incidents of objectionable or unwelcome conduct, comment, bullying, or action by a person that the person knows or ought reasonably to know will or would cause offense or humiliation to a worker, or which adversely affects the worker's health and safety. This includes discrimination and sexual harassment, but excludes any reasonable conduct of an employer or supervisor in respect of the management of workers or a work site. So my first recommendation is, when developing your policy, make sure that harassment is a defined term. One of the key things that I saw a lot when the changes to the legislation were announced and people were having their policies updated was that even well after the legislation had been changed, many employers had not modified their policy to expand their definition to include personal harassment. That was a sort of a new addition to the Occupational Health and Safety Act. It historically only applied to workplace violence, and sexual harassment was something that we had typically covered in all of our policies, largely because of our human rights obligations. Now, we also need to consider personal harassment, which includes any form of unwelcome conduct, comments, images, or contact. So examples of this would be excluding people in the office, isolating them, intimidating them, bullying, so name calling, harassing phone calls, gossip or rumors, yelling, slamming doors, and sort of more subversive behavior like setting people up for failure, withholding information that is required to do their job effectively. So again, make sure that when you're reviewing your policy, which hopefully everyone will turn around and do after we have this discussion, to make sure that your definition covers not only sexual harassment, but also personal harassment. Violence. Occupational health and safety defines violence as whether at a work site or work-related, the threatened, attempted, or actual conduct of a person that causes or is likely to cause physical or psychological injury or harm, and includes domestic and sexual violence. So workplace violence can include physical attacks or aggression, so hitting, shoving, pushing, or kicking, throwing an object, threatening behavior such as shaking a fist in a worker's face, wielding a weapon at work, trying to hit someone, trying to run down a worker using a vehicle or equipment, destroying property, throwing objects, verbal or written threats, leaving threatening notes, sending threatening emails to express an intent to inflict harm, of course, domestic violence, which is covered under Part 27 of the Code, or sexual violence. You know, from time to time, I do see allegations of workplace violence. Probably most recently, the allegation that I dealt with was an attempted collision with a pedestrian. So two workers, one is a pedestrian, one is operating a vehicle, and the employee operating a vehicle is alleged to have attempted to strike the pedestrian with a vehicle. Certainly, I've handled all manner of claims involving violence or attempted violence at the workplace. So pushing, punching, but you know, overall, these are much less common than the incidents of personal or sexual harassment, which, you know, we see not infrequently. And, you know, in terms of allegations of personal harassment, I would say that those have been increasing. It's hard to say whether that's, again, the cultural shift. You know, I think probably these kinds of things have always been going on in the workplace, but there's a bit of a greater recognition that these things do represent harassment, and that it's not just, you know, harassment of a sexual nature or connected to other grounds of discrimination, such as, you know, racism or, you know, discriminating against someone based on their place of origin or their status as a parent, for example. I think there's just increasing awareness that these types of behaviors constitute harassment and are unwelcome. You know, like slamming doors, slamming your fist down on your desk, slamming your phone down. So, you know, it's important to educate your staff about, you know, what is workplace harassment? What are all the various forms of workplace harassment? So again, as I mentioned in the opening, the legislation sets out specific duties for each of the following groups. Employers must, as far as reasonably practicable, ensure their workers are not subject to or participate in harassment or violence at the workplace. Supervisors must, as far as reasonably practicable, ensure workers under their supervision are not subject to harassment or violence at a work site, and workers must refrain from causing or participating in harassment or violence. One of sort of the big social issues that we talk about in connection with harassment is how do we overcome the bystander effect? So, you know, where there are multiple people witnessing a certain type of behavior or conduct, you know, there is that sort of diffusion of responsibility. And when, you know, perhaps there's that social pressure of, well, this person here seems to be accepting of this behavior. Perhaps it's just me. Perhaps, you know, my barometer's off in terms of what's acceptable conduct in the workplace. So we really need to think about how do we foster a culture of non-tolerance of this kind of behavior, and how do we empower people to come forward or to stand up and say, you know, to either confront people who are engaging in harassing behavior, or to, you know, report it pursuant to your policy, just as a bystander, just as someone who's witnessed it, not someone who's been affected by the harassment directly. But again, I think part of that is educating your employees about, you know, that goes to the workplace culture. You know, even if it ultimately doesn't affect you, you know, that sort of tolerance for that kind of behavior over time sort of erodes your workplace culture, and you know, can lead to a toxic working environment, which can expose you to various risks. As with all occupational health and safety duties, the standard is due diligence. So, you know, unlike other areas of the law where, you know, the test might be sort of a strict liability test. So if a person is exposed to harassment, there can be liability flowing from that harassment to the employer, even though obviously the employer had no direct agency in it. If it was a coworker, if it was a supervisor. With occupational health and safety, the obligation is simply to take steps that are reasonable, make sure that you act reasonably in the circumstances to assess the hazard and prevent the hazard as best as possible. So obviously, at a minimum, that's going to be complying with your occupational health and safety duties in terms of policy drafting, hazard assessment, and implementation. So what steps do you have to take to prevent harassment in the workplace under occupational health and safety? You have to develop hazard assessments and training. You need to develop a violence and harassment prevention plan. You need to investigate and take corrective action, and you need to advise employees on treatment options for workers harmed by violence or harassment. So again, hazard assessment, what does that look like? So again, the way we need to think about harassment is it's an occupational hazard like any other occupational hazard. So you need to really think about the context of your workplace and what types of risks are your employees exposed to. So, for example, in a municipal context where you have someone working in a customer service capacity and they have direct interaction with the public, that's a potential hazard for that employee, where we need to think about, okay, how do we, if there's a harassment incident that escalates at let's say the reception desk, how do we protect the safety of that employee? So maybe we'll use physical barriers, maybe we'll have plexiglass, which again, in this post-COVID day and age, plexiglass is like a necessity, a bare minimum for protecting your workers from these other new risks that have arisen. Having doors to the area where your staff is, have some kind of security access system to prevent people from coming around the front counter. So we need to, we need to really think very specifically about our workplace design, and all the various access points that they might have to people who could expose them to harassment. We also will have an obligation to involve our employees and the health and safety committee or your health and safety representative, depending on the size of your organization. We also want to ensure that we've provided preventative training to our employees. What is helpful about this obligation to engage employees is they can sort of firsthand give you an assessment of what are the particular risks that they're exposed to based on their experience working in a particular workplace. And once we recognize these real or potential hazards, then we can start taking steps to eliminate or control them. So like we talked about, we set up physical barriers, we secure access points to, have some physical spacing between our staff and the public. For example, if you worked at Miramax, maybe you're going to move your interviews away from hotel rooms. These are all the things you have to think about your particular working environment and the particular risks. When you're providing training, you should be going over, how do I recognize violence and harassment? Again, what are workplace violence? What is workplace violence? What is workplace harassment? Another sort of key part of this training is going to be going over appropriate workplace conduct, knowledge of how the policies and procedures work. So who bears what obligations? How do you report? What kind of documentation do we expect? And how do you go about obtaining assistance with either reporting or assistance through the EAP program. How do you get access to resources when you're someone who's been subjected to workplace harassment? I think especially with the evolution that we've had in terms of what's harassment and what is harassing behavior, and we have people in our workplace that are kind of have worked through the sort of different eras, it's important to have sort of a huddle on this and sort of regroup about what's acceptable and what's not acceptable, because as you know, this has evolved over the years. And I think that some people who worked in a different particular working environment, things that were appropriate 10 years ago are today wholly inappropriate. So there's been a real evolution on this, and I think we can't sort of lose sight of that. We need to be training people in what's appropriate workplace culture. And, we need to think about, as an employer, what kind of steps do we take to maintain a particular workplace culture? So I recall a case where an employer had tried to terminate an employee for cause for some, particularly egregious and sort of gross, frankly, workplace behavior. So, having lewd pictures posted at his desk, like pornographic images, sending around emails, chain emails with images and videos in them to his colleagues, to customers, to clients, having a sort of a level of discourse in the workplace that was offensive and inappropriate. And ultimately, when the employer tried to terminate this employee for cause in connection with all of these inappropriate workplace behaviors, the court found that the employer had had knowledge of this behavior, and that they had, at a minimum, sort of contributed to this, the creation of this culture of workplace behavior, and by not doing anything, and had sort of in that way tacitly permitted it to exist. So that, failure on the part of the employer to step up and address this behavior as it was happening, and really waiting until someone came forward and said, I find this to be inappropriate behavior, that undermined their ability to ultimately conclude the employee's employment for cause. So in terms of developing a harassment and violence prevention plan, we need to, this is really just going to be your harassment policy. We need to have comprehensive policies and procedures that set out expectations for behaviors, responsibilities for various parties that are affected by the policy. So that would be, the complainant, the respondent, who's the investigating party, and other employees who are perhaps witnessing the behavior. So it would include reporting and investigating procedures, what are the rules around confidentiality, what types of corrective action can flow, and what are our policy review obligations. Obviously, it goes without saying that the policy, in sort of the policy statement, needs to make clear that harassment and violence will not be tolerated in the workplace, and that consequences for such behavior will follow, and setting out the various consequences that might result. So, things like obviously discipline, training, providing an apology, referring to an EAP service, and perhaps another counseling service if you have access to that, or even potentially, based on the severity of the allegations, filing a police report. Your harassment prevention policy has, you have certain statutorily required elements. So your policy needs to clearly indicate that you're committed to eliminating the hazard of harassment, or if the hazard cannot be eliminated, that it be controlled. You need to have a statement that you are committed to investigating all incidents of harassment and taking corrective action to address the incidents. You need to address confidentiality and confirm that disclosure will happen only where necessary to investigate the incident or take corrective action, to inform the parties involved in the incident of the results of the investigation and the corrective action taken, or as required by law. You also have to have a statement that the harassment prevention policy is not intended to discourage a worker from exercising rights pursuant to any other law, including the Alberta Human Rights Act. Your prevention procedures must include a reporting procedure, the procedure that the employer is expected to follow when documenting, investigating, and implementing controls to prevent harassment, and the procedure which must align with the policy for employers when informing the parties involved in an incident of harassment of the results of the investigation and the corrective action to be taken. You must, with respect to your violence prevention policy, it must contain the same provisions as the harassment policy, but it must also include that the employer will disclose only the minimum amount of personal information required that is necessary to inform workers of a specific or general threat of violence or potential violence. So because they are so similar in terms of what is statutorily required, it really makes sense just to combine them into one single policy. There is also another section in the legislation dealing with just violence that affects specific workplaces, like you must have safe cash handling procedures, including procedures which minimize worker access to money, maintaining visibility in and out of a work site, limiting access by the public to the interior of buildings at a work site, monitoring by video surveillance, and there are specific requirements also for work sites open to the public between 11 p.m. and 5 a.m. There are also, as I mentioned, there are review obligations. So your harassment and violence prevention programs must be reviewed at least every 3 years or earlier if an incident occurs, or if your workplace health and safety committee or representative recommends a review. Again, we need to involve the affected workers in the review, the health and safety committee, or the representative, depending on what you have in your workplace. So, generally speaking, just to give sort of a basic overview, you want to make sure that you have your definitions in there. What is harassment, including sexual harassment, including discrimination. This is a great place to have your sort of anti-discrimination provisions. Also personal harassment. In terms of confidentiality, as many of you know, particularly if you've ever handled one of these before, if you're going to take corrective action, which may include discipline, you have to think about procedural fairness. So it needs to be made clear in your policy and probably procedurally when you're discussing the process with the reporting employee, who may be the victim or maybe another witnessing employee. It needs to be explained to them that for the purposes of your investigation and for the purposes of permitting the responding party to really respond to the allegations, they need to be able to present the allegations, including the identity of the complainant, to the alleged harasser. And of course, the statute recognizes that to do a full investigation and to present the findings of the investigation and to take corrective action, there has to be that disclosure obligation. So as I noted, there is an obligation to conduct an investigation and to take corrective action. This will include generating an investigation report, and there are also specific record-keeping obligations in the statute. Typically, we recommend with investigation that the policy either allows you to strike an in-house investigation committee, or that you alternatively retain a third-party investigator. you want to make sure that the language in the policy is such that you have the discretion as the employer to choose which route you're going to take. So, depending on the severity of the allegations, you may want to hire a third-party investigator, which, can come at a significant cost. I think the last workplace investigation that I had retained an investigator for cost something in the realm of, $20,000. So they can be quite costly. So I think you don't want your policy to commit you in all cases to using a third-party investigator. Now, of course, the cost of the investigation, even using a third-party investigator, is going to fluctuate based on how serious the allegations are, how widespread the problem is in the workplace. So, from that, how many witnesses they're going to need to interview, and how involved the allegations are they over a long period of time. So all those elements will affect the cost of an investigation. At the end of the day, I think retaining a third party to investigate the allegations is always sort of the gold standard. It's the best practice. But again, it's certainly not necessary in all cases. And so long as we can prove that there's some independence there's freedom from bias. The people who are investigating the complaint are not people who are implicated in the harassment. I think there's no problem with using sort of an in-house investigative committee. That said, if you're going to do that, you need to make sure that that committee has some proper training in how to conduct investigations. So they need to understand these elements of procedural fairness. They need to understand their record keeping obligations. If you have a collective agreement that impacts your workplace, they obviously need to be alive to what are their obligations in terms of involving the union for both the investigation and delivering any disciplinary action that might flow from the investigation. I think it is helpful to have timelines in the investigation provisions of your policy. We need to be careful that they're not so unreasonable that they're too onerous, because sometimes these things can evolve, and there might be cases where you end up having to expand your investigation beyond what you originally thought based on allegations that arise during the course of investigation. So make sure that the timelines are reasonable, but I do think that the timelines are valuable to help keep things moving along. I certainly, I was recently involved in a matter where the investigation spanned something like 9 months. Especially if you're going to, if the allegations are of a particular severity and you're going to be suspending any of the parties that are alleged to have been involved, as a perpetrator, which of course would be a paid suspension, because until the allegations are fully investigated, we can't take any punitive action against the respondent. So, if you were to suspend someone without pay, that would be, akin to sort of predetermination of the merits of the allegations without full investigation. So obviously, it would not be ideal to have someone on an investigative suspension and have them be paid for 9 months and not work while you investigate the allegations. So I think it's important to make sure that it moves along in some kind of timely fashion. And I think having a timeline set out in your policy is helpful for that. I've also certainly seen investigations that never seem to come to any kind of resolution. So again, I think timelines are valuable for that. As we talked about confidentiality, make sure that that's in your policy when you are prepared to guarantee confidentiality and when you cannot. We also have to keep in mind that we might have statutory disclosure obligations. So we may have to file a police report. And again, we always need to think about, if we're going to take action in respect of the allegations, which we are obligated by occupational health and safety to take corrective action, what kind of procedural fairness steps do we need to take? So, we need to give the perpetrator a detailed accounting of the allegations and provide them with an opportunity to respond. We, as indicated on the slide, we have to develop an investigation report, and it must be retained for 2 years on file. We would recommend that these records be retained indefinitely. You'd never want to be in a situation where perhaps you have major turnover and there's some kind of organizational knowledge that's lost there, that maybe an incident occurred between 2 employees, and then later have something happen where, for example, the employee who was the harassee ends up reporting to the harasser. There was a case, I believe in Ontario, where that happened, where there was some serious harassment allegations. An employee was ultimately terminated in connection with the harassment allegations, and then years later was rehired to the organization, and sort of that organizational knowledge, including the harassment report, had been lost or destroyed, and this person was basically rehired to supervise the person that he had been found to be harassing. And as you can imagine, there were some pretty extraordinary damages awarded against the employer in that case, for the sort of trauma that caused the harassee, who circumstantially also had raised with the employer at the time that it was happening that this person had historically been involved in harassment, and in fact had their employment concluded in connection with this harassment. So I think, I guess there may be some obligations in your collective agreement about record keeping that you need to follow if your workplace is bound by a collective agreement. So keep that in mind. But, wherever possible, we would say try and preserve these records somehow, obviously maintaining the confidentiality of the records. So, if, for example, if you have a number of different parties in your organization that may have access to personnel files, you could think about keeping these investigation related documents in some kind of sealed envelope in the personnel file of both the complainant and the respondent, denoting that it's private and confidential, and even, putting on directly on the envelope who are the parties that can actually look at the contents of the envelope. So in terms of the sort of fallout in connection with harassment, as probably most of you know now, sexual harassment constitutes gender-based discrimination under human rights legislation. Employers can be held liable for their employees' actions where they fail to take prompt and appropriate action to prevent and or stop harassment. So what's going to be key from an employer's perspective in terms of defending yourself from these allegations is going to be that we had a policy, at a minimum, I'm going to say following all of your statutory duties, so following all the occupational health and safety duties in connection with having a harassment and violence prevention policy are going to be your mechanism for showing that, at a minimum, you complied with all of your obligations. Another key element is going to be that you followed your policy. So, this is why it's important to provide training to employees, and particularly supervisors and managers that are going to be working with the policy and responding to complaints under the policy, walking them through the policy, making sure that they understand that the policy exists, how it works, how it's supposed to be applied, and sort of teaching them how to document the steps that they took in reference to the policy. The Supreme Court of Canada has defined sexual harassment in the workplace as unwelcome conduct of a sexual nature that detrimentally affects the work environment or leads to adverse job-related consequences for the victims of harassment. There's really sort of 2 ways that human rights allegations can arise in connection with harassment. One, of course, is sexual harassment, and the other could be any form of personal harassment that's connected to a prohibited ground. So again, as I mentioned, this could include remarks connected to someone's race, their ethnicity, their place of origin, their marital status, their family status. So their, if someone was being harassed because they were a parent, for example, you know, or, you know, because of their relationship to a particular person in the workplace. Those are all incidents through which human rights allegations could arise. Of course, where harassment is also discriminatory, there's going to be a duty under her human rights legislation for the employer to take prompt and effectual action if you have, you know, had awareness or you should have known of an employee's conduct in the workplace which may amount to sexual harassment or discrimination. It's key that you know, anytime you have knowledge or potential knowledge of this kind of behavior, that you take the necessary steps to make some inquiry into this behavior. Because of course, if it comes out later that, well, there were prior reports of a particular kind of behavior happening in the workplace, you know, that's really going to undermine your ability to argue that you took steps to prevent the behavior, or you know, will lead to an allegation that you had sort of a permissive approach to the conduct or allowed it to continue. You know, it's everybody, I think, is well aware that workplace harassment commonly has some consequences, which, you know, commonly we see complaints of psychological or mental illness flowing from workplace harassment allegations. So then there will be further obligations that will arise in connection with this illness or disability that has arisen from the harassment. In that case, we'll have to think about what are our accommodation obligations. So probably the number one thing we see in connection with workplace harassment is we'll see employees initiate medical leaves of absence and then sometimes attempt to come back with restrictions or limitations. This is an area I'm sure many of you have sort of interacted with these types of allegations, and this is an area in which we see a lot of very directed restrictions from physicians. So, you know, a lot of this employee can't work with this employee can't be supervised by this employee can't work in proximity to this person, this employee can't work at the customer service desk, this employee can't work in this particular workspace, they can't work in this building. You know, these kinds of restrictions can be difficult because, you know, in my view, the physician is there to explain the medical restrictions or limitations, and then it is for us to consider how we sort of operationalize that in our workplace. How do we ensure that we meet the restrictions or limitations based on what the physician provides to us, rather than having the physician dictate to us exactly what the employee can or can't do in the workplace. But in practice, you know, it's very difficult to deal with these when the physician is sort of overstepping their boundaries. As probably most of you know at this point, the duty to accommodate is to the point of undue hardship. Undue hardship is a flexible standard, and it will change depending on the character of your workplace, the particular employee, where they fit in your workplace, the financial cost associated with accommodating the employee, the effect on employee morale, and, you know, the safety risks that might be involved. So, you know, recently we were assisting an employer with a post-traumatic stress disorder claim, and the employee was a
Jenelle, we seem to have lost you for a second here. Can you hear me?
Uh-oh, did I lose you guys?
You're back now.
Okay,
I think we've lost your presentation, though, at least on my screen we have.
okay. Let me just try again here.
No problem.
Hopefully that I didn't disappear for long. Can you see my screen yet?
I can't see it yet.
Okay.
Oh, there we go.
I have to advance a little bit here.
Sure, you're back.
So obviously we'll have to, so in this case, the employee, not only could he not return to his job, he could not work in the building that he had previously worked in, which was the building that sort of housed the fire department and the EMS staff. And he couldn't work in any building or position where he would have frequent contact with any employees working in that department. And so given the context of the employer, even though the employee potentially had some other skills that he could use, that the employer could move them into a different role, because of the size of the organization, there was, practically speaking, no way to completely eliminate contact with anyone working in that particular department, because it was a large department for the employer. So ultimately, it ended up going the direction of undue hardship, which there is an entire process under the workers' compensation legislation to recognize cases of undue hardship. So to talk about the Workers' Compensation Act, you know, as any other workplace injury, if there's trauma, psychological trauma or injury arising from workplace conduct, which certainly can arise from harassment of all kinds, it will be recognized as a compensable injury. The sort of limitations of this are, of course, it has to have led to a diagnosable injury or illness. It has to be beyond the threshold of, just stress. And again, the definition indicates that reasonable action by supervisors to manage and direct a worker does not constitute harassment. I would also recommend building that language into your policy, as there is a recognition both on the occupational health and safety side and on the workers' compensation side that reasonable direction of a workplace by a supervisor does not constitute harassment. So it's important to keep in mind too that the way that the Workers' Compensation Act has defined workplace harassment, it can involve a single or repeated incidents of objectionable or unwelcome conduct, comment, bullying, or action intended to intimidate, offend, degrade, or humiliate a particular person or group. So, where it can result from a single interaction between two employees, there really is very little margin for error here. So that's why, we really see the value in providing that workplace education piece to educate your employers on, what is harassing behavior. The Workers' Compensation Act has a number of requirements, such as maintaining benefits while the employee is away from work. There is also an obligation to reinstate. So employers and workers must cooperate with one another to facilitate a return to work once the worker is cleared to return to work. This obligation to reinstate will end when the employee declines to return to work. There is now a statutory duty to accommodate a return to work, including modified work to the point of undue hardship. I have on a few occasions made an undue hardship argument, and there's a particular process that you need to go through the Workers' Compensation Board to make an undue hardship claim, so that you don't, where it's circumstantially not possible, you don't need to bring the employee back to the workplace. Another important thing to remember is that if you do bring the employee back to work, if the worker is terminated within 6 months of returning or while in receipt of benefits under the Act, there's a presumption built into the legislation that you did not meet this obligation unless you can provide evidence that there was an appropriate and valid business reason to terminate, which is unrelated to the work injury. It's important in that case that the evidence is clear. We've certainly seen a fair bit of this happening lately with sort of the COVID-related pressures on workplaces. So this is another sort of, key reason why it's important to have and keep proper documentation surrounding employee management obligations. So, whether it's that you had a restructuring, when I talk to employers about position eliminations, I typically say, the sort of gold standard would be that you had a third party conduct an independent review of your organization and look at your organizational efficiencies and inefficiencies, and that third party identified these various positions as being targeted for elimination or restructuring. That doesn't always have to be the case, but certainly, we need to have some sort of way to show there was a reasoned process that we've reduced to writing, that we were looking at our organizational structure, and that these decisions were at a minimum sort of in the works before the employee commenced their medical leave of absence. If we need to keep in mind too that if it's performance related, we need to have proper documentation of, disciplinary action taken or concerns that we have, so that if we're in a position to terminate, while they're on medical leave or shortly after they've returned from medical leave, that you can, clearly persuade the WCB that it had no relationship to their illness, that these performance problems predated their leave of absence, or what we see in a lot of cases is an employee goes off on leave, someone else covers them, and then we uncover all of this, problematic workplace behavior, like, work that's not been completed, work that's not been properly performed, perhaps negligent workplace conduct. So we just need to make sure that we create and keep proper documentation of those things, so that where necessary, we're not limited by this obligation in the Workers' Compensation Act. If you fail to return a worker to work, WCB can impose a financial penalty of up to 1 year's salary. So why comply? I mean, other than that it's the law and that you're supposed to, if you follow your occupational health and safety obligations closely, you'll minimize your risk of constructive dismissal claims. So typically, constructive dismissal claims result from personal harassment or from the creation of a toxic working environment. Obviously, grievances, which can be based on constructive dismissal, can be based on human rights allegations, human rights complaints, workers' compensation penalties, occupational health and safety penalties and prosecution, and of course, negative reputational impacts. So just the general word of mouth that exists about your workplace. This can affect your ability to recruit good employees, to keep good employees, and ultimately, the credibility that your organization has overall. Complying with these sort of minimum statutory duties contained in the occupational health and safety legislation is going to be the sort of minimum threshold for demonstrating that you took action and had proper preventative measures in place. Certainly, demonstrating that you've complied with your various occupational health and safety obligations will assist you in demonstrating that you took reasonable steps to prevent or stop harassment or discrimination in your workplace. So what are some practical tips for policy development? Think about having formal and informal complaint resolution mechanisms. So obviously you want a stream or a channel where you can send things forward for investigation. And I think you want that channel to be able to be employee or employer triggered as well. So even if the particular employee may not want to trigger a full investigation, you may want to reserve the right to do that based on the nature of the allegation. So, for example, if you suspect it has a wider workplace impact, again, you need to look into those allegations. You can't just sort of turn a blind eye to that because, if something develops in future and it is revealed in the process that you knew about it or had some potential awareness of it and you didn't do anything, then that creates risk for you. An informal complaint resolution mechanism might be something like a mediation or just sort of an informal meeting between the alleged harasser and the harassee. Of course, that's going to be more suitable for sort of minor misconduct allegations and not sort of the more serious variety that you might see. We need to think about ways to both practically and through our policy empower bystanders. So have a mechanism in the policy that it's not just someone who's been subject to harassment. It's anyone who's, witnessed any workplace behavior that violates the policy. And, in addition to creating a mechanism for them to do this, also create a positive obligation for people to report things that they see that violate the policy. We want to have an ability to trigger an investigation based on systemic harassment or workplace violence. You want to make sure that your policy addresses retaliatory behavior and prohibits retaliation, because I've had numerous files where retaliation has spurred further complaints. So I had a case where I had 3 employees in a single workplace complaining that they'd been harassed by their supervisor, which following the complaint, it was a human rights complaint, following the complaint being received and provided to the employer for response, then further actions that happened in the workplace resulted in 3 separate retaliation complaints. So we were dealing with a total of 6 complaints of discrimination. You want to make sure that you have set out clearly what the consequences are of your policy violation. You want to have various types of responses. So you might want to send an employee for training. You might want to have them participate in a mediation. You might want them to provide an apology. You want the policy to make clear that discipline is a potential outcome up to and including termination for cause. You also want to make sure that you have some language in the policy that deals with what you can do if the complaint is not found to have merit versus if the complaint is found to be based on false or vexatious allegations. And recognizing that there's a difference between the two. I had an investigation recently that resolved, that found that the reporting employee had a genuine belief that the behaviors that he was subjected to in the workplace were harassing in nature. The complaint was not made falsely or maliciously, but ultimately, the behavior didn't amount to harassment. Particularly when you looked at the context of the workplace, that other employees were subjected to the same kind of behavior and that the same expectations existed for employees throughout the workplace. We also have an obligation to refer employees for treatment following incidents of harassment and violence, which flows from the Occupational Health and Safety Code. So this is where you might refer employees to your employee family and assistance programs. And how do we facilitate that with employees? Do we have the contact information right in the policy? How do we accommodate them seeking treatment? So we might want to have language in there that, we're committed to accommodating them obtaining any kind of treatment that they need. So that might mean time away from work, access to their sick time, medical leave of absence in the event that they need that. in the bigger picture, we need to understand that workplace harassment may lead to psychological harm or trauma that is going to require accommodation by the employer. So the more sort of accommodating we can be of people seeking treatment and obtaining the help that they need, I think the better chance we're going to have of reintegrating them into the working environment and potentially avoiding a long medical leave of absence, disability claim, or a workers' compensation claim. Oh, I think I guess I've gotten to the end of my my slides here. So we're pretty close to the end of the time. I'm sorry, I just went on and on, but certainly if anyone has any questions, I'm happy to answer them at this point. Alternatively, I know Dave has my contact information, and certainly he can share it if anyone wants to reach out and talk about any specific issues that I touched on today, or talk through any scenarios that they might have in their workplace.
Yeah, absolutely. Thank you, Jenelle, for offering that. I think what we'll do, because we're right at 11, if anyone needs to sign off, please feel free. I do have a question on the chat. So Jenelle, are you okay if we just take a couple minutes maybe and answer questions, and anyone who needs to sign off can go?
Yeah, of course.
All right. So someone just asked if you could repeat your comment on what the duty to inquire was.
So yes, so there's much that's been made about the duty to inquire, and it's really not as sort of broad as it's sometimes characterized to be. It's really just in cases where it's really just that employers aren't going to be allowed to be sort of willfully blind. And so if you see a significant change in someone's conduct or behavior in the workplace that is atypical, not characteristic of how they've historically been, it's notable, it's a change, that's a case where you're going to have to make active inquiries to sort of get to the bottom of what's going on. So, for example, if you have an employee who suddenly is having very frequent incidents of absenteeism, lateness to work, where that person had always been arriving to work in a very timely fashion, then that's a case where you should be, meeting with the employee and addressing with them, we've noticed this behavior. Is there any problem there? Are there any external factors that are contributing to this? So it's really just, you can't disregard red flags in the employee's behavior. But, if you have no reason to suspect that there might be any kind of issue with the employee, you don't just have a blanket obligation to inquire.
Thank you. So any other questions, feel free to send them through on the chat. I just had one question. I was wondering, Jenelle, if you could expand a little bit on when you talk about educating your employees and supervisors on the policy, to what level of detail? Like I just am thinking of scenarios for some people where they feel the line has moved on them. What used to be acceptable or what used to garner maybe an eye roll is no longer acceptable behavior. And to what level of obligation do employers have to educate employees on their policy? And what level of detail is even in the policy?
In terms of educating employees on our policy, I would really just be kind of taking them step by step through the policy. So going through the definitions, perhaps giving some examples. So, we have clients that do training, and we've facilitated training. There are certainly organizations that deliver respect in the workplace training that deal more with those kinds of issues, like what, more examples and scenarios of, this is harassing, this is this would constitute personal harassment, this would constitute discrimination, sort of walking through those scenarios. And certainly, we have clients that we do presentations for that have like role play. We role play certain scenarios of appropriate dialogue, inappropriate dialogue. But really, in terms of training on your policy, I would really just be walking people through, here's our definitions, here are reporting mechanisms, here's who you go to if you have a complaint to raise, here's, this is what this is what an investigation is going to look like. These are what confidentiality, obligations we have and you can expect us to meet. Here's what information you're going to be expected to share. This is the timeline for the investigation. This is going to be how we'll resolve it. These are the possible consequences. It would be a more sort of step-by-step to make sure that people understand what are the contents of the policy, what are your expectations, where they can find the policy, and what resources they can access.
Okay, great, thank you. Another question is a scenario about the timing of a complaint. So somebody had a scenario where they got a complaint about harassment that had occurred 2 years ago. So how would you recommend people approach this in terms of acting promptly?
Again, in that case, I think your exposure is going to be fairly limited because you didn't have the relevant knowledge. But I think even in that case, particularly so long as the alleged perpetrator is still in your workplace, I think that's a case where, even though a long time has passed and, witnesses may be gone, people's recollection of incidents may be gone, I think that's, still there's that sort of due diligence element there where you should be still investigating that to the best of your ability. Because if it were to come out later that, the alleged perpetrator had a new victim and was harassing someone else, and then it comes out that, well, you knew that there had been these allegations about this historical harassment, if a bit stale, it's, I think it really, you're not going to meet your obligations to be ensuring that you're preventing workplace harassment. So, I think, and also we have to keep in mind that some of the sort of limitations on harassing behavior, particularly sexual harassment, sexual assault in the workplace, some of those bars to making claims that are very old have been removed. And there are sort of, some discoverability rules. So while that wouldn't really apply in the case of two adults, let's say you're in a school environment and it's, the accused is a teacher and the person who was harassed was a student, particularly if they were a minor at the time, that could have pretty far-reaching implications in terms of time. So even if a long time has passed, that's not necessarily going to limit your liability like it will, say, between two adults where, for example, if someone's sexually harassed at work, a human rights complaint, you only have a year to make a human rights complaint. So it'll vary depending on the context. But again, I think, even if it's old, you still have to the best of your ability, try and do an investigation.
Okay, and to build on that, does the obligation apply to an employee who complains, for example, that council is harassing them in the municipal world? Do elected officials get special privilege?
No, elected officials do not get special privilege. And I would say from a human rights perspective, they have a quite broad definition of what is an employee, so what is harassment in employment. And so even though a council member is not strictly speaking an employee of a municipality, they're an elected official, I think in the context of a human rights complaint, you could still bring that under employment discrimination, and the Human Rights Commission could find that that constituted discrimination in employment. In terms of how the municipality deals with it, it is a little bit more complicated because, again, they're not employees, so you can't necessarily subject council members to the same sanctions that you would be able to with employees. So, that's why it's important to have sort of a council code of conduct, and you'd be dealing with it through those mechanisms rather than necessarily your harassment policy. However, I think on the employer's side, you're still going to investigate it like you would investigate any other harassment allegation, even though the alleged harasser is not technically an employee. So you're still going to run it through your policy, and you're going to interview witnesses. You're going to do all those things. It's just when it comes to how do you deal with the resolution, that will be governed by your code of conduct for your counselors.
Thank you. I'll turn it back over to Dave now, maybe to wrap up. If there are any questions that you maybe didn't want to ask to the group, or that you want to send to Jenelle directly, I think that channel's been opened. So
yeah, absolutely.
Great.
Yeah. Well, thank you, everybody. And thank you, Jenelle, very much for providing that great presentation. I do sometimes regret that we don't make this a little longer just so people can stick around and have more of a discussion at the end. But we do appreciate everybody staying to this point. A recording of this session will be up on our website under the Insights tab shortly. Again, I forgot to press record at the beginning, so I think Jenelle did as well. We'll just see who hit that first and how much we can get. I think mostly of what you missed is just me talking, so that's okay. We have a couple giveaways today. One is the book by Barry LaValle. Some of you might have come to this. It was at the zoo a couple years ago. It's So You Think You're Ready to Retire. We have 2 of these, and we'll include as well our world famous Hillcrest socks. So the skill testing question to win this is the first 2 people to email me with the answer to what was Jenelle's first recommendation in developing a harassment policy. Not what the definition was, but what was her first recommendation in developing the policy. Also, stay tuned for our next Hillcrest at Home newsletter that's coming out. As you know, it's different from our regular newsletter, which is a little more formal. Hillcrest at Home is a more informal, kind of cheeky view of how our team is coping at home. And this episode, or this version, actually has a little bit about the Hillcrest honey extraction that happened in July, and we got some great honey this year. It looks like this, and there's a good story in there about how I got stung a lot, but also just a little description of how it's done. And in regards to the honey, this is the time of year that we're delivering honey, and everybody loves it. We're just having a really hard time with that this year because of COVID. We don't know if you're in the office. We're not traveling very much. So we've given away some, but if you're looking for it and you happen to be in Calgary and in the Kensington area, we would just love if you'd stop by our office, take a tour of our new place. We would be socially distanced and hopefully not too socially awkward, but you could pick up your honey at that time, maybe even have a cup of coffee with us. So again, thanks, Jenelle. Thanks everybody else for being here. Do look for the recording of this on our website. Thanks again.
Thanks, guys.
Thank you.